good to see everyone. We have a little bit of a light turnout today. I think, what do we got? 35, 40 people? It's
Yep.
still people coming on. So we have 35, 40 people. Usually we get a little bit more. Happy Friday. It's beautiful out there. Maybe that's why. Or maybe just people are media weary on this stuff, right? I thought it was somewhat timely, but watching TV, you really feel like turning your TV off these days. But so the topic today is everything old is new again, free speech, flashback. If you judge by the TV personalities and the talking heads you see every morning and every night, they would think that this kind of free speech stuff is all new. And in fact, for those of us who've been around long enough, which most of us look like we've been around long enough, know that this free speech stuff has been a hot topic for a long time. And for a long time, people have been trying to take over campuses and the president's office and all this other good stuff. This goes back prior to the founding of the country, and it's a big part of the reason why the country has the First Amendment and why the state constitution has the right to free speech in the state constitution. So today we're going to talk about free speech, briefly, not exhaustively. As you know, tens of thousands of gallons of ink have been spilled over what free speech means, why we should have free speech, when can you have free speech, who can have free speech, all that good stuff. And it has not always been the same thing in terms of interpretation. So we have the dog of the day, right? Happy day, dogs of the day. We have two dogs today. This is on the left-hand side. That's Bowie at the beach. Bowie at the beach. He's a multi-poo. I think it's a he, right? And then Lexi's on the right. That's a Shih Tzu. And they belong to Stacy Homa from Atlantic Realty Solutions. It used to just be Atlantic Realty. Now it's Atlantic Realty Solutions. So thanks so much, Stacy. If you're out there, we appreciate sending the dogs of the day, and we'll work that into the calendar, I think, right, Crystal? Yep. Yep. So great picture. Thanks for sending it in, Stacy. So we're just going to jump right into it. Why do we care about free speech? Why do we care about free speech? Well, there's a lot of reasons we care about free speech. It's the touchstone of America, right? It's probably the most liberal country in the world. And when I say liberal, I don't mean screaming liberal, you must do this, I must do that, or conservative, you must do it my way or the highway. No, not liberal or conservative that way, just liberal in terms of allowing speech, right, and expression. Probably the most liberal in the world, right? Thank you. Thank you so much to the founding fathers that we have the right to free speech, right? That we have the right to free speech at the federal level and also at the state level. And why? What are some of the theories behind free speech? Oh, there's Weston Denon. He's on his trip. He's on a cruise, Weston, and he shows up for First Friday with Fran. Thanks, Weston. Nice to see you. So people have the right to hear what others want to say, right? We all want to hear what people have to say. It doesn't mean we want to hear everything that people have to say. It doesn't mean we can't walk away from it. It doesn't say we must hear what they have to say. It doesn't mean we can't shut off our TV or change a channel or walk away from the public forum. But we want to have the freedom to have the opportunity to hear what people have to say. It's part of what we are as people. When what people say is part of who they are, right? So you identify who you are by what you say, what you advocate for, what you express every day, right? So it's an important part of who we are. It defines to the larger world what we have to say and who we are. When it comes to that theory, one of the odd things about recent, we'll say, free speech has been that so many of these so-called free speakers don't seem to want to be identified and often wear facial coverings and masks. So to me, I find that very odd because I have been involved as a lawyer and as a private citizen also in some very contentious, hot issues, as you might imagine. And I want people to know who I am. I want people to know why I'm saying what I have to say, and whether or not they agree with me, I want them to know that this is how I feel and this is what I think. So America is a representative democracy. So how could people intelligently vote if they could not listen to others' viewpoints and then offer their own viewpoints and try to convince others of how they feel, what they think? More important than how you feel is actually what you think. So free speech is essential to critical thinking, right? Free speech is critical for critical thinking. It's part of critical thinking. It's not the Dark Ages, right? The Dark Ages are what? Dogma, dogma. You will think and say what we tell you to think and say. When in fact, free speech allows for the exchange of ideas. People change their mind. There's nothing wrong with changing your mind. You discuss new ideas. You think about new things. You can be convinced of other things. One of the things I appreciate most about law school, even though I didn't love law school, I felt like law school was an unpaid job for 3 years, is it really forced me to think. It challenged me to think all the time. And even if I didn't work as an attorney, I would say that going to law school is a good education just for that. If you don't decide to be a practicing attorney, I'm not trying to force my kids to be practicing attorney. It is a very hard job and it is a grind at times. But I would say the law school education does force you to think and look at the world in different ways, not just in a linear way. So that I find it very helpful. So, and free speech checks intolerance, and state power as well. So as much as some people believe that free speech actually promotes intolerance, the thing about free speech is that it allows others to counter speech with their own speech. And in fact, I believe it obligates people to speak, right? Not everyone agrees with me on that, but I think it definitely does allow people to, we'll say, speak truth to power, speak truth to the government, speak truth to opposing viewpoints. And certainly it checks dictatorial power, right? So governments with power to censure and limit free speech tend to abuse that power. And we know that, right? Whether it was Germany or Japan or Italy, these fascist countries, what do they first want to clamp down on? Communication and free speech, because it's going to be our way or the highway. They're going to tell you what to say, tell you what to think, tell you how it's going to be. So free speech in the US is, as I said, probably the freest of any country in the world. And I think that's a wonderful thing for all of us. But the flip side of it is that it also, I think, requires us to speak our minds if we are going to be part of a representative democracy. So what is the test for free speech? Is it anything goes? And the answer is almost, right? Sometimes it feels like almost, even though that's uncomfortable, right? The Constitution, there's no provision in the Constitution that says, and you shall be comfortable. No. In fact, oftentimes when we're talking about free speech, it's very uncomfortable. And the case of Brandenburg versus Ohio is a very uncomfortable case. For any of you who are out there who want to take a peek at it, it is a short case, very brief case, probably 3-4 pages long. It's not one of these United States Supreme Court cases that goes on 45 pages of single space lines. So you can take a peek at Brandenburg. Brandenburg versus Ohio is a wacky case. One of these guys who's like, I'm a Ku Klux Klan member and I'm going to do all this crazy stuff and I'm going to march on Washington and we're going to hate Jewish people, we're going to hate black people, we're going to hate everybody, right? And we're going to march around on our farm with guns, etc. But nobody else is going to be there. We're not going to threaten people personally, but we're basically going to make speeches that, espouse all types of wacky, in my opinion, viewpoints. And then we're going to march on Washington and march on, I think it was Virginia, and march on, perhaps Memphis. And for some reason, he was marching on something in Florida too. Very odd speeches, right? But very hateful speeches. Nevertheless, the court said, unlike the old school clear and present danger test, which many of us probably saw in our civics class in high school, that was, everyone says you can't shout fire in a theater. Probably everyone said that. You actually can shout fire in a theater, but you can shout fire in a theater if the theater is on fire. You can't shout fire in a theater just to terrorize the theater and make everyone stampede toward the doors and hurt themselves, right? So that was the clear and present danger test, and the example was shouting fire in a theater when there was no fire, just to hurt people. That's clear and present danger. The court in Brandenburg got away from that and actually expanded the free speech rights there. And what the court said, I'm sorry for taking my glasses off, but I guess I still haven't gotten new glasses, everybody. But so the constitutional guarantees of free speech and press do not permit a state to forbid or prescribe advocacy of the use of force or a violation of the law except where such advocacy is directed to inciting or producing. So that's checklist number one, directed to inciting or producing imminent. That means right now, lawless action, okay, directed at inciting or producing imminent lawless action and is likely to incite or produce that action. So you can't even be a speaker like this wacky KKK guy and trying to incite or produce lawless action, but it's not imminent and it's not likely to produce this action because nobody else was there. One of the things that I find very interesting about the Brandenburg versus Ohio case is this guy, I guess it was Brandenburg, actually called a TV station ahead of time, ahead of him and his 12 buddies having this little party on his farm, and said, hey, come on out. We're going to have this KKK rally on our farm. And the media went there, right? And videotaped, at the time it was televised, and they taped it, and then they replayed it later in the day, and then Brandenburg was arrested, I believe, on this, and then later sued Ohio. The thing is, why in the world would a TV station show up for this? So I do think the media does have some role in this type of thing with respect to why in the world would they show up and televise such a thing, right? I mean, sometimes, the media does have the right to do such things, but at times I think the media should exercise some judgment on what they are putting out there. I know that's kind of old-fashioned thinking, but to me, I don't know. If somebody called me and said, hey, you want to come fill my KKK rally? I probably would not show up. I would probably hang up the phone. But anyway, that's Brandenburg versus Ohio, and that's the test. It's a very broad test, right? These people, the Brandenburg people, were doing bad things, in my opinion, right? Personal opinion, not legal opinion, but personal opinion. And in a perfect world, would they not say such things? Of course they wouldn't say such things. But under American law, it's permitted. And then the big question that comes up for us all the time is, but isn't the association's property private property? So why do we have to give the right to free speech on our private property? The association's private. I live in a private community association. Some of them are even gated. And that case comes down to really a couple cases. It starts with the case of State versus Schmid. For any of you who have seen State versus Schmid, that's Princeton University, right? It doesn't say the Princeton University case, but it's the State versus Schmid. What happened was Mr. Schmid was a leafleteer, a political leafleteer on Princeton University's campus. This was in, I guess, the late 60s, early 70s, for the Labor Party, and he was trying to turn over I think, an election in Newark, New Jersey. But he went out there and was doing leafleting, and Princeton University said, hey, you're violating our rules and regulations. You can't be here. This is private property. What are you doing here? And the state, they pressed charges for trespassing on Princeton University's private property. What the court did there, it was the New Jersey State Supreme Court, said, well, we look at this and we're not so sure that the federal First Amendment right applies. However, and this is we get into condo associations. However, we find that the state constitution does apply, and under the state constitution, we've developed a three-pronged test. What the three-pronged test is: the nature, purpose, and primary use of such private property and its normal use. And in Princeton University's case, what was happening there is Princeton University had rules and regulations that were, I would call, very ill-defined, if you will. So certain people could come on and speak. Other people would be prohibited from coming on. But the university did allow their private property to be used as a public forum for speaking, for leafleting, and things like that. And what the court said is, well, in terms of the nature, purposes, and primary use of the property, the university property, even though it is private property, it has and is being used as a forum for public discourse. So basically, Princeton University, not only did you open the door to public discourse, you also did not regulate it in an even-handed way, right? Your rules and regulations are unclear, they're ambiguous. and Mr. Schmidt can't be held accountable for trespassing. The extent and nature of the public's invitation to use the property. So again, in Princeton University, when you're reviewing the test criteria, Princeton University did allow people to come in and have public speaking there. They actually let people come on campus, certain people, and hand out flyers and give speeches, etc. Number three, the purpose of the expressional activity undertaken on such property in relation to the private and public use of the property. So in this case, Princeton University, again, as a place of discourse and a place of higher learning, if you will, allowed topics for debate, allowed topics that were not always mainstream topics. And it was not unusual for people to go to Princeton and talk about unusual topics or topics that people generally don't agree on. And number four, which was added on by another case called the Coalition Against War versus JMB Property Realty, the reasonable restriction, there has a balancing test. Is it reasonable? Okay, we balance the test. And why did that happen? The add-on case there was after Princeton University, there were cases involving shopping malls. Everyone may remember shopping mall cases where the arguments there were the shopping malls have become in the 70s and 80s, et cetera, Main Street. So if you have private shopping malls that have subsumed the role of Main Street, USA, how else could I reach these people in public places, even though it was private property? The entire population of the town is at the mall rather than on Main Street anymore, right? And the courts basically said, what we're taking is the Princeton University test, and we're adding on the balancing test from the Coalition Against War versus the Realty Company. And we're going to say, if the three-part test in Schmidt is satisfied, plus the balancing of the Coalition Against War, the private property owner is going to have to allow certain reasonable expressional rights on that private property. And that's essentially what the analysis was in the Committee for a Better Twin Rivers versus Twin Rivers. I don't know if any of you live in Twin Rivers. Twin Rivers is a huge community off of Route 33 over there, and I guess it's East Windsor. I guess it's East Windsor. And that case really was a test case. It was undertaken largely by the Rutgers Newark, I think, Public Policy Clinic. There was a professor there that pushed that case, and several students worked on the case, I guess more or less pro bono. And really what they were seeking to do there, which they were unsuccessful in doing, was saying a community association's role in the residential community can be so pervasive that it becomes a governmental entity for the purposes of law, just as would a municipal government. Therefore, it's subject to the same constraints as a municipal government. New Jersey Supreme Court said no, that is not the case. The control that a community association or homeowners association exercises, at least in this instance, does not rise to the level of being construed as a public governmental entity like the state or the federal government. Therefore, it's not subject to the regular restraints on public entities. However, the court in Twin Rivers said, we are looking at the Princeton Schmidt analysis as well as the Coalition Against War case, and we're going to basically apply that test here in Twin Rivers. The good news is in Twin Rivers, the Supreme Court felt that the association was acting, we'll say, more or less reasonably. The association had not invited the public, unlike Princeton University and unlike the shopping malls, was not inviting the public. Its primary purpose was not a public purpose, again, unlike the shopping malls. So that didn't tick that box either. And the purpose of the expressional activity, although in Twin Rivers was political, so people were putting political signs in the planting bed, balancing the rights of expressional activity of the members vis-a-vis the private property nature in Twin Rivers, the association acted reasonably because it did allow its members to put one sign in each one of their planting beds, and I think it allowed one sign in each one of their windows. So Twin Rivers, although the court found that the association was not really bound by the Schmidt test, the Princeton University test, because they didn't invite the public there, and the nature of the community was residential and not public, like the shopping malls, the association was doing reasonable things in terms of the balancing and allowing rights of free expression without clamping down on everything. Mazda Brook, on the other, I have a little note on Mazda Brook, similar analysis, but the court went a little bit further, basically saying the reasonable restrictions should be clearly written in advance and made known to the relevant community members. So in Mazda Brook, and I was at the Mazda Brook oral argument in the Supreme Court with a friend of mine, the Mazda Brook court there, New Jersey Supreme Court said, basically, the candidates for office have a right of expression and free speech, and Mazda Brook did not have the ability to limit all speech. So the Mazda Brook Association essentially, unlike Twin Rivers, prohibited all types of expression. Although I do think Mazda Brook, in limited circumstances, allowed for sale signs in one window in the house. So what happened there was in Mazda Brook, one candidate was running for office. He put a picture of himself, vote for me, in his front door window, and the association violated him for doing that. And the court said, no, your restrictions are too tight. And even though you don't invite the public, and even though the community is residential in nature, you are still too tight, and you're not giving any avenue for reasonable expression. And Mazda Brook was required to allow the candidate to put the sign in the office. I'm sorry, not in the office, in the front window of his house. So the question then again on free speech, but what about when these people are lying scumbags, right? And this comes, and you've heard me say this before, right? Because this is one of the problems, right? One of the problems and why this is such a hot topic right now is the internet is pervasive, right? So people say all types of wacky, evil, bad, lying things on the internet every day. They also say all kinds of wonderful, good things in the internet every day. But does that mean if you think someone's a lying scumbag, you should shut down their speech? And no, as I've referenced Justice Brandeis a number of times in First Fridays with Fran, the remedy to be applied is more speech, not enforced silence, right? Because when you get involved in enforced silence, who decides who to enforce the silence against, right? Not only are you putting a certain group in charge with a certain set of beliefs, you're limiting everyone's discussion rights, right? Once one group comes to power, they will limit the rights of everyone else. So as Justice Anthony Kennedy also said, the response to an unreason is the rational, right? The response to the uninformed or ignorant is the enlightened. And to the straight out lie is the simple truth. So the problem with so much communication today is that people have to be disabused of lies. And it's upon all of us, it's the burden upon all of us to, in my opinion, speak, right? Speak the truth as you know it. Because if you do not, someone else will speak their truth for you. And, there is there's a really good poem on that. First they came for the socialists, I think. I forget how it goes right now, but there's a really good poem. First they came for the socialists, and I said nothing because I was not a socialist. I don't have the authority. I'll give you a citation on that later, but a very good poem. We're all obligated to speak. And I know I sound naive when I say that, but the alternative is not good. So the other thing to keep in mind about associations is there are a number of cases outside of the free speech realm, although they do conflate free speech with contract claims. And the reason for that is cases like Twin Rivers and Mazda Brook, although they involve members, they also, in Twin Rivers in particular, involve some non-member issues and whether they could speak there. There are cases in associations where it's only members. So, for example, distributing candidate flyers for membership to the board, etc. There may be an issue there that just not only involves free speech under the federal and state constitution, it also involves a contract and corporate law claim. Because they say, listen, even if free speech test doesn't apply, I am a member of the corporation. Therefore, I have a right to distribute information regarding my candidacy for the board, or what I think of the association's finance committee, et cetera. Does that make sense? It's a little bit, it sounds like free speech, and it often involves free speech, and the cases discuss free speech, but there's a second aspect of it in terms of a contract claim. I am a member of the organization. I have a right to communicate with other members based on corporate law. Okay, so it's a little different. So is it okay to smash windows, shut down bridges, and close schools, etc.? Absolutely not. No. Can you threaten people? I'm going to punch you in the head, you dirty so-and-so. No, that is not free speech. That is not protected speech. Can I block you from going over the bridge? No. Can I shut down the turnpike? No. Can I shut down your school? No. Can I prevent exams from taking place? No. Can I prevent your kids from graduating at the graduation ceremony at your kid's university? No. That is all illegal activity, illegal activity. Civil disobedience is by definition a violation of the civil code, right? Civil disobedience. Notwithstanding that, civil disobedience has been used for hundreds of years and probably thousands of years, probably since the beginning of time, to highlight certain issues, right? And to try and use civil disobedience as to give a forum or a platform for the message. The issue is, it is still a violation of law, and you may still be prosecuted, right? For the violation of law. You are taking your chances. So when I find it very odd when people come on TV and are outraged because they've done something illegal, and they are claiming that they should not be removed from streets or buildings or parking lots or bridges or schools, right? When they're blocking students from doing what the students should be doing at the university and what they're paying for. So civil disobedience is used as a tool. It has been used forever. The famous pictures of, and tragic pictures at times, we all know about from the 60s and 70s, whether it's the civil rights movement or the anti-war movement in Vietnam. We've seen the pictures from Kent State. We've seen the pictures of people walking across the bridge and being attacked by officers with fire hoses and police dogs and so forth. So there is civil disobedience, which can be highly risky, but it is still illegal. Saying that it's speech or expressional activity does not make it okay and legal, right? So again, you must speak. Some of the other examples of where speech got crazy is the Lincoln administration. So Lincoln himself, Abraham Lincoln, clamped down very tightly on free speech during the Civil War. Woodrow Wilson clamped down very, very tightly on free speech during World War I. In Vietnam, I could show you a picture of, for those Rutgers alums, right? This is the occupation of Old Queens during, I believe this was during an anti-war Vietnam protest during the 70s or the late 60s. So Old Queens at Rutgers was not occupied during the recent protests, but it has been occupied in the past. This was during Mason Gross's administration. For any of you who know Mason Gross, he was a president at Rutgers. So in the context of civil disobedience, people again must understand that you don't get a pass, and you shouldn't get a pass for civil disobedience. Again, that's why I find it so strange right now that people who are engaging in civil disobedience don't seem to be willing to identify themselves or to put themselves out there. That seems very strange because it's very counterintuitive. Free speech itself, just say a few words about free speech. I'm not going to get too political. So one of the big issues with free speech, and I'll read the, let's see, 1 second. It's interesting, right? The free speech, First Amendment under the United States Constitution. So Congress shall make no law respecting an establishment of religion. This is just the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. So that's all together. And it's interesting that free speech and free exercise and anti-establishment are all included in the same amendment, right? And the reason I suspect why the founding fathers put some of those concepts all together is one man's scripture is another man's blasphemy, right? And under the founding fathers' paradigm, there was a separation, a clear and strict separation of church and state. And those concepts all flow together, right? Because once you get religion mixed with governance, if one man's scripture is another man's blasphemy, how do you have a real debate politically? You cannot, right? Unless you have free speech, right? Because the end of the discussion is because you cite whatever happens to be the book or the man or the woman or the person. And that's the end of the story, because you just point to that and say that is the authority, end of discussion. So it is, and I do think it is genius that the founding fathers incorporated things like free speech, anti-establishment, and free exercise of religion in a very short, terse statement that really has made this country work so well, right? But I do want people to be very clear that civil disobedience is illegal and it should not be happening. So, do we have any questions? Chat? Nobody's doing anything? No?
Well, Fran, actually one of the lawyers, Rich Linderman in the office, asked, what are your thoughts on giving equal time to insurgents and association newsletters and cable channels, bulletin boards of, the naysayers, the difficult individuals in the community?
Yeah, we would generally call them the gadflies. So Twin Rivers talked about that somewhat. If you look at the Twin Rivers case, Rich, you're probably familiar with it, but in Twin Rivers, they really didn't force the issue. The court didn't force the issue. It's a mixed issue in terms of free speech and, again, corporate rights. If you have a community association newsletter, does the association have the obligation to allow every naysayer to print their article about how much I hate the board in the newsletter? My answer to that would be no. But there is, I would have to take another look at the Twin Rivers case and see how far that went. There were issues of the newsletter in Twin Rivers, and there were also issues of a bulletin board in Twin Rivers. I think the concept there is, does the other group, we'll say the group who is momentarily out of power, does the other group have the ability to communicate? And the cases where associations have gotten in trouble is, one of them was Galaxy Towers, for example. They actually attempted to prevent the group that was out of power from slipping flyers under the doors of the members talking about their grievances. Okay.
And Fran, one more question in the chat here, which kind of opens up a whole nother Pandora's box of questions, which is something like Facebook or whatever social media platform, where's the line, right? So somebody's posting on there, these idiots in charge, talking about board members, XYZ. And then at some point it continues, and then they end up saying that the board and the management are stealing and that they're unethical and, so on and so forth. So I think maybe the question is, at what point does the association respond? Do we react?
Right. So that's a really good question. And by the way, Marcia, thanks for the poem. Did I see Marcia still with us? There she is. Yeah. Thanks for putting that out there. That's words to the wise right there. So what would Mark? Sorry, Mike, I lost my train of thought there.
So talking about social media, and at what point?
Okay, so social media, right? So, and Mike and I've dealt with this a lot. On social media, generally the same touchstone applies. People can say what they want. Where social media gets funky is too often we see a disgruntled board member or a disgruntled homeowner posting messages and posting websites that suggest or lead people mistakenly to believe that they represent the association, they represent the management company, or they are speaking for the management company or for the board. That's a problem, right? So you can stop people from, we'll say, misleading people. So some of the I mentioned before, one of the examples that's not free speech is true threats. Fighting words. Fighting words is another example. I go up to a police officer and I say, I'm here to kick your butt. Pure fighting words. And even that's a little funky right now in terms of how much people can prosecute fighting words. There's still, believe it or not, an exception for obscenity. So if people there's a separate test for obscenity, speech and obscenity. But what we're really thinking about is defamation and fraud. So defamation and fraud are not protected speech, defamation and fraud. So if you're a doctor or a lawyer or a rabbi or a priest or whatever, I can't just make up stuff about you and post it on the internet without being subject to defamation. I can't go nanny nanny poo poo. It's it's a free country and I have free speech and I can say whatever I want. So defamation, libel laws still apply. So people can go after you for that. You know, the big case is you've heard me mention it before, the Belia case, where Hulk Hogan, his real name is Belia, went after a website for publishing information about him and his girlfriend and putting videos up there. So the again, free speech is pretty broad on the internet, Mike. The question is, are they misleading people? Are they lying at people, lying about people? Are they engaging in defamation or fraud? You know, send me the money. That's not protected conduct. You know, lying about somebody, not protected conduct. The cases where we get a little crazy is we'll get board members or board presidents saying, I want to sue so-and-so for defamation. The problem with that, it's a very high standard because you're considered a quasi-public figure, and it's to get a defamation or a libel claim against somebody who's a public figure, a quasi-public figure. You have a very high bar to show that that they purposely hurt you, right? It's not the lower bar. It's not, oh, I should have known better. It's not that. No, you have to, it's a very high bar for public figures in the US. Not so in England. You know, as you see, you know, Prince this and Prince that and Princess this, you know, they file cases against the Sun and the Inquirer and all that nonsense. In the United States, public figures must show a much higher level. So most association board members are disappointed to hear that they can't sue their adversaries for defamation or libel. Yeah, there's one from Jim there. Oh, that's the Facebook one. Yeah. So we've been especially in adult communities, with time on their hands, some people spend a lot of time posting bad things against their political enemies. Yes. So Mike and I have spent a lot of time at board meetings trying to get people to play nice in the sandbox. And they say, I have free speech, man. Leave me alone. I'm going to keep calling him names. So, you know, I don't want to be a preacher myself or a rabbi or a priest and trying to say, hey, everyone be cool. But I would really love everyone to be cool outside of the free speech laws. It's getting harder and harder, it seems. The other thing that's interesting is there are some groups that would take advantage of, we'll call liberal America free speech standards to impose standards that entirely exclude free speech. So that's the danger of a liberal democracy and not speaking out. If certain people would have their way, they would limit free speech to everyone except themselves. So that's something that is very dicey about living in a free place like we have here. But that's also the beauty of what we have here. You know, people aren't dictating to any of us what we have to say, what we have to listen to, or what we have to think. So there was a next one there.
You know, I actually just had a comment, a direct comment to me, and I could touch on it.
Sure.
So it was just kind of off topic, asking about the Corporate Transparency Act and if there's been any update. So for those, there's no update since March, but for those who don't know, the Corporate Transparency Act apparently applies to community associations and requires that the decision makers, the board members, will need to register on the federal database. Fran went through an entire Friday with Fran on this and showed everybody how to do it. In March of this year, a federal judge, it was a district court ruling, I think out of the Northern District of Alabama. They found that the Corporate Transparency Act, as it pertained to the plaintiff in that case, which was the National Small Business Association, was deemed unconstitutional. So currently, National Small Business Association doesn't need to comply with that and their members, but it only pertains to them. So the question is, where do associations stand? I think it's still up in the air. The compliance date is the end of this year. It's marked December 31st, 2024. So I would suggest sitting tight for now, unless you think otherwise, Fran.
No, I think as far as we're concerned in the Third Circuit, which, is New Jersey and Pennsylvania, et cetera, we still have to comply. I mean, many associations, I think, are taking kind of a wait and see approach. In a lot of cases, a lot of people don't feel compliance has been very onerous. There are also, though, some, I guess, people that are kind of more in the libertarian spectrum. They're like, Fran, I only want to have to give my information if it's a last possible resort, which I understand completely as well. So those people in that part of the spectrum are saying, hey, we're going to wait and see. Let's wait and see. I don't think you want to wait to the last minute, though, because the sanctions are fairly high if they decide to impose sanctions. What can be done about owners slipping flyers under the doors and publishing notices on the common areas? So the publishing notices in the common areas, you would have to pass a rule and regulation as far as publishing notices in the common areas. The Twin Rivers talked about they have one of those glass case bulletin boards at, I think, in the clubhouse or at the back of the clubhouse. But you don't want people, the classic, for those of you who have seen the ganged mailboxes, the ganged mailboxes in condo associations where they have like 30 mailboxes and everyone drives up after work and gets them. People tape junk all over them, and then they look really trashy because the flyers start to rip and tear and fall apart. You really have to decide what you want to do about flyers. Again, it's time, place, and manner. Time, place, and manner. Time, place, and manner you're allowed to regulate. Time, place, and manner. Time, place, and manner. So when it can be there, how they can do it, right? Where they can do it, time, place, and manner. The association can regulate that reasonably. Where do associations get themselves in trouble with speech? Content regulation. You can't post anything in a picture about religion. You can't post anything about abortion. You can't post anything about politicians. You can't post anything about Democrats. You can't post anything about Republicans. That's where you get yourself in trouble. That's content regulation, and New Jersey Supreme Court especially would frown on that big time. The other thing you cannot do is, even if you understand that you can't regulate content, you also can't regulate viewpoint, which is a little bit tougher to deal with sometimes. So people will say, well, we don't prevent political speech as long as you're a Republican, right? That's viewpoint. That's viewpoint discrimination, which is illegal also. Same thing. We don't prohibit political speech as long as you're a Democrat. Same thing. So it has to be not only content neutral, it has to be viewpoint neutral, right? So it can't be, hey, you can talk about abortion, but it has to be in the context of pro-choice, or you can talk about abortion, but it has to be on the other side of the debate, right? So that's viewpoint neutral. So it has to be content neutral and viewpoint neutral. And people get really, really excited about that because they say, Fran, we just want to have nice flags. And I say, well, if you have nice flags, you have to let everyone have their flags. Who's the judge of what a nice flag is, right? Go Giants means you get to put a flag up there that says something else. As I've explained to all of you before, I've had cases where, people have torn down the Israeli flag off people's balconies, which is ridiculous. I've had people who've torn flags down. I don't even know what this flag means, but the flag of Lebanon has been torn down off of balconies. So I don't really exactly know what these people's motivations have been over the years, but it just shouldn't happen. But the thing is, once you have those flags, once you have flags and displays, etc., it's time, place, and manner. I have some associations that say, well, Fran, we allow everything, but nothing religious. I go, what? What? That's craziness, right? That's not content neutral, right? So if you're going to allow things, it has to be time, place, and manner. Time, place, and manner, but not we're regulating what you say, right? You can regulate how you say it. And you can't, it has to be viewpoint neutral as well. Go ahead, Mike, sorry.
Anna wrote, my boss used to advise us to use the red face test, which is how we would react if he said the newspaper headline. So
Yeah, that's an interesting test. So, and I'd have to say in today's world, uh, you have to be willing to be uncomfortable. You have to be willing to be uncomfortable, I would say. Perhaps the red face test may not apply anymore, or it may apply in less circumstances. Uh, but I think the number of people who are willing to speak their truth assertively suggests that you would probably have to speak your truth assertively. And when I say assertively, I'm not talking about violence or threatening or any other nonsense or taking over buildings or stopping classes. But I think that speech has to be met with speech. Writing has to be met with writing, right? Media has to be met with media. And by the way, where is this going to get really, really crazy, really, really soon? And Mike and I have talked about this. AI, right? Artificial intelligence. Artificial intelligence is going to populate the universe like nobody's business with ideas, concepts, quote, thoughts based on we don't know what. We don't know what. So it may become harder and harder to parse what is fact-based, what is rationally based, and what is not, what is lies, what are total outright falsehoods. And that requires us not only to, like I said, speak the truth, speak our truth, but try very hard to parse what is the truth and what is not the truth, right? We can't rely on a single source, right? Nobody can rely on a single source today. Everyone knows that every media outlet has its own bias, right? Which is a real problem for all of us. I don't believe that there was ever a day in the past where there was a media outlet that wasn't biased. Everyone's heard back in history class, yellow journalism, all this other stuff going back forever. In the Civil War and Revolutionary times, the media was biased. But I think especially with the advent of the internet and AI, it's going to require more and more work by all of us to try and find the truth, seek the truth, and speak the truth as we know it. So, sorry, what was next?
So what if a board member who is a moderator of the unofficial association Facebook website and who posts comments or doesn't moderate comments that cause conflict and disruption, and who promotes bad relations amongst members where the association's code of conduct specifically prohibits those comments? If free speech covers conduct, is the particular section in the association's code of ethics unconstitutional?
So I would have to look, Ivan, I'd have to look at the particular interest. That is a little bit too narrow for this forum. So I'd have to look at that in particular. But thanks for the question. Is it going to make us think everything through? Oh yeah, so that's a
You're
great.
talking AI.
Yeah, hey Bill. Yeah, that is a great comment. It is going to make all of us have to think everything through, right? And what AI is going to try to offer all of us, I think, is this is the truth. Believe it, right? And the great news is, you know, the people in this forum think about stuff, which is great. I think about stuff. Sometimes I think I'm right. The next day I think I'm wrong, right? I change my mind, right? People should be open-minded. People should be susceptible to new interpretations, right? People should be susceptible to new evidence. That's the beauty of free speech under the American system. So again, I'm moralizing probably too much, so I apologize for that. So anyway,
That's it, Fran. Yeah, no other questions.
that's it. Well, it was great seeing everyone. I hope everyone out there is safe. I hope all your family members are safe. I hope everyone is doing well, and please keep speaking. Great to see everyone. Thanks so much for attending. Have a great weekend.